Okay, just after the Hudson versus Michigan case is Herring versus United States. Still within the exclusionary rule section, but not for much longer. So this will be, I think, the last case and maybe some summary. Chief Justice Roberts delivered the opinion of the court. The Fourth Amendment forbids unreasonable searches and seizures. And this usually requires the police to have probable cause or a warrant before making an arrest. What if an officer reasonably believes there is an outstanding arrest warrant? That belief turns out to be wrong because of a negligent bookkeeping error by another police employee. The parties here agree that the ensuing arrest is still a violation of the Fourth Amendment, but dispute whether contraband found during a search incident to that arrest must be excluded in later prosecution. Our cases establish that such suppression is not an automatic consequence of the Fourth Amendment violation. Instead, the question turns on the culpability of the police and the potential of the exclusion to deter wrongful police conduct. And here, the error was the result of isolated negligence attenuated from the arrest. We hold that in the circumstances that the jury should not be barred from considering all of the evidence. Okay, in these circumstances, right? On July 7th, 2004, Mark Anderson learned that Benny Dean Herring had driven to the Coffee County Sheriff's Department to retrieve something from his impounded truck. Herring was no stranger to law enforcement, and Anderson asked the county's warrant clerk, Sandy Pope, to check for any outstanding warrants for Herring's arrest. When she found none, Anderson asked Pope to check with Sharon Morgan, her counterpart in neighboring Dale County. After checking Dale County's computer database, Morgan replied that there was an active arrest for Herring's failure to appear on a felony charge. Pope relayed the information to Anderson and asked Morgan to fax it over a copy of the warrant as confirmation. Anderson and a deputy followed Herring as he left the impound lot, pulling him over and arrested him. A search incident to the arrest revealed methamphetamine in Herring's pocket and a pistol, which as a felon he could not possess in his vehicle. There had, however, been a mistake about the warrant. The Dale County Sheriff's computers records are supposed to correspond to actual arrest warrants, which the office also maintains. But when Morgan went to the files to retrieve the actual warrant to fax Pope, Morgan wasn't able to find it. She called the court clerk and learned that the warrant had been recalled 5 months earlier. Normally, when a warrant is recalled, the court clerk's office or adjust chambers calls Morgan, who enters the information in the sheriff's computer database and disposes of the physical copy. For whatever reason, the information about the recall of the warrant for Herring did not appear in the database. Morgan immediately called Pope to alert her to the mix-up, and Pope contacted Anderson over secure radio. This all unfolded in 10 to 15 minutes, but Herring had already been arrested and found with the gun and drugs just a few hundred yards from the sheriff's office. Herring was indicted in the district court for the Middle District of Alabama for illegally possessing a gun and drugs. He moved to suppress the evidence on the ground that his initial arrest had been illegal because the warrant had been rescinded. The magistrate judge recommended denying the motion because the arresting officers had acted in good faith belief that the warrant was still outstanding. The district court adopted the magistrate judge's recommendation, and the Court of Appeals affirmed. So the Fourth Amendment's the rule, and I kind of found the issue somewhere else. Okay, so the 11th Circuit found that the arresting officers in Coffee County were innocent of any wrongdoing or carelessness. The court assumed that whoever failed to update the Dale County Sheriff's records was also a law enforcement official, but noted that the conduct in question was a negligent failure to act, not a deliberate or tactical choice to act. Because the error was merely negligent and attenuated from the arrest, the 11th Circuit concluded that the benefit of suppressing the evidence would be marginal or non-existent, and the evidence was therefore admissible under the good faith rule of the United States v. Leon. The fact that a Fourth Amendment violation occurred, i.e. that a search or arrest was unreasonable, does not necessarily mean that the exclusionary rule applies. First, the exclusionary rule is not an individual right and applies only where it results in appreciable deterrence. Leon. We have repeatedly rejected the argument that exclusion is a necessary consequence of the Fourth Amendment violation. Leon, Arizona v. Evans, Pennsylvania Board of Probation and Parole v. Scott. Instead, we have focused on the efficacy of the rule in deterring the Fourth Amendment violations in the future. In addition, the benefits of deterrent must outweigh the costs. Leon Supra. We have never suggested that the exclusionary rule must apply in every circumstance in which it might provide marginal deterrence. Scott. To the extent that application of the exclusionary rule could provide some incremental deterrent, that possible benefit must be weighed against a substantial social cost. Illinois v. Kroll. The principal cost of applying the rule is, of course, letting guilty and possibly dangerous defendants go free, something that offends basic concepts of the criminal justice system from Leon. These principles are reflected in the holding of Leon. When police act under a warrant that is invalid for lack of probable cause, the exclusionary rule does not apply if the police acted in objectively reasonable reliance on the subsequently invalidated search warrant. We, perhaps confusingly, call this objectively reasonable reliance good faith. In companion case Massachusetts v. Shepard, we held that the exclusionary rule did not apply when a warrant was invalid because a judge forgot to make clerical corrections to it. Shortly thereafter, we extended these holdings to warrantless administrative searches performed in good faith reliance on the statute, later declared unconstitutional. Kroll. Finally, in Evans, we applied this good faith rule to police who reasonably relied on mistaken information in a court's database that an arrest warrant was outstanding. The extent to which the exclusionary rule is justified by these deterrence principles varies with the culpability of the law enforcement conduct. As we said in Leon, an assessment of the flagrancy of the police misconduct constitutes an important step in the calculus of applying the exclusionary rule. Similarly, in Kroll, we elaborated that evidence should be suppressed only if it can be said that the law enforcement officer had knowledge or may properly be discharged with knowledge that the search was unconstitutional under the Fourth Amendment. Anticipating a good faith exception to the exclusionary rule, Judge Friendly wrote that the beneficent aim of the exclusionary rule to deter police misconduct can be sufficiently accomplished by a practice outlawing evidence obtained by flagrant or deliberate violation of rights. The Bill of Rights as a Code of Criminal Procedure, and it gives a citation. Indeed, the abuses that gave rise to the exclusionary rule featured intentional conduct that was patently unconstitutional. In Weeks v. United States, 1914, a foundational exclusionary rule case, the officers had broken into the defendant's home using a key shown to them by a neighbor, confiscated incriminating papers, and then returned with the U.S. Marshal to confiscate even more. And not only did they have no search warrant, which the court held was required, but they could not have gotten one had they tried. Equally flagrant conduct was at issue in Mapp versus Ohio, which extended the exclusionary rule to the states. Officers forced open a door to Miss Mapp's house, kept her lawyer from entering, brandished what the court concluded was a false warrant, then forced her into handcuffs and canvassed the house for obscenity. An error that arises from non-recurring and attenuated negligence is thus far removed from the core concerns that led us to adopt the rule in the first place. In fact, since Leon, we have never applied the rule to exclude evidence obtained in violation of the Fourth Amendment, where the police conduct was no more intentional or culpable than this. To trigger the exclusionary rule, police conduct must be sufficiently deliberate that exclusion can meaningfully deter it, and sufficiently culpable that such deterrence is worth the price paid by the justice system. As laid out in our cases, the exclusionary rule serves to deter deliberate, reckless, or grossly negligent conduct, or in some circumstances, recurring or systemic negligence. The error in this case does not rise to that level. So this is like the new legislative intent. Well, it's not even legislation. Whatever. And our decision in Franks versus Delaware provides an analogy. In Franks, we held that police negligence in obtaining a warrant did not even rise to the level of Fourth Amendment violation, let alone meet the more stringent test for triggering the exclusionary rule. We held that the Constitution allowed defendants in some circumstances to challenge the truthfulness of factual statements made in an affidavit supporting a warrant even after the warrant had issued. If those false statements were necessary to the magistrate judge's probable cause determination, the warrant would be voided. But we did not find probable cause determination. The warrant would be, But we did not find all false statements relevant. There must be allegations of deliberate falsehood or of reckless disregard for the truth, and the allegations of negligence or innocent mistake are insufficient. So that would be how to handle it in a go-forward manner. So both this case and Franks concern false information provided by police. Under Franks, negligent police communication in the course of acquiring a warrant do not provide a basis to rescind a warrant and render a search or arrest invalid. Here, the miscommunication occurred in a different context after the warrant had been issued and recalled. But that fact should not require excluding the evidence obtained. The pertinent analysis of deterrence and culpability is objective, not an inquiry into the objective or subjective awareness of arresting officers. We have already held that our good faith inquiry is confined to the objectively ascertainable question whether a reasonably well-trained officer would have known that the search was illegal in light of all the circumstances. Leon. These circumstances frequently include a particular officer's knowledge and experience, but that does not make the test any more subjective than one for probable cause, which looks to an officer's knowledge and experience, but not his subjective intent. We do not suggest that all record-keeping errors by the police are immune from the exclusionary rule. So they're not really making like a bright line requirement. In this case, however, the conduct or across-the-board requirement. However, the conduct at issue was not so objectively culpable as to require exclusion. In Leon, we held that the marginal or non-existent benefits produced by suppressing evidence obtained in objectively reasonable reliance on a subsequently the substantial cost of exclusion. The same is true when evidence is obtained in objectively reasonable reliance on a subsequently recalled warrant. If the police have been shown to be reckless in maintaining a warrant system or to have knowingly made false entries to lay the groundwork for future false arrests, exclusion would certainly be justified under our cases should such misconduct cause a Fourth Amendment violation. The dissent also adverts to the possible unreliability of the number of databases not relevant to this case. In a case where systemic errors are demonstrated, it might be reckless for officers to rely on an unreliable warrant system, but there is no evidence that errors in Dales County system are routine or widespread. The judgment of the Court of Appeals for the 11th Circuit is affirmed. Justice Ginsburg, with whom Justice Stevens, Souter, and Breyer joined dissenting. Beyond doubt, a main objective of the rule is to deter and to compel respect for the constitutional guarantee in the only effectively available way by removing the incentive to disregard it. But the rule also serves other important purposes. Enables the judiciary to avoid the taint of partnership in official lawlessness, and it assures the people, all potential victims of unlawful government conduct, that the government would not profit from its lawless behavior, thus minimizing the risk of seriously undermining popular trust in the government. The exclusionary rule, the court suggests, is capable of only marginal deterrence when the misconduct at issue is merely careless, not intentional, or reckless. The suggestion runs counter to the foundational premise of tort law that liability for negligence, i.e. lack of due care, creates an incentive to act with greater care. The government also acknowledges that the mistake here involved the failure to make a computer entry hardly means that application of the exclusionary rule would have minimal value. Just as the risk of respondent superior liability encourages employers to supervise their employees' conduct more carefully, so the risk of exclusion of evidence encourages policymakers and system managers to monitor the performance of the systems they install and the personnel employed to operate those systems. Consider the potential impact of a decision applying the exclusionary rule in this case. So I hate entertaining these cases, but what they're saying is it has more than a minimum value to exclude the evidence, right? And then they're talking about a duty, but so did the majority opinion. But I guess they just wanted a different outcome. So anyway, consider the potential impact of a decision applying the exclusionary rule in this case. We, as earlier observed, the record indicates that there is no electronic connection between the warrant database and Dale County's Sheriff Department and that of the County Circuit Clerk's office, which is located in the basement of the same building. When a warrant is recalled, one of the many different people that have access to the warrants must find the hard copy of the warrant in the 2 or 3 different places where the department houses warrants. Return it to the clerk's office and manually update the department's database. The record reflects no routine practice of checking the database for accuracy, and the failure to remove the entry for Herring's warrant was not discovered until investigator Anderson sought to pursue Herring 5 months later. It is not altogether obvious that the department could take further precautions to ensure the integrity of its database. The Sheriff Department is in a position to remedy the situation and might well do so if the exclusionary rule is there to remove the incentive to do otherwise. Is the potential deterrence here worth the cost it imposes? In light of the paramount importance of accurate record keeping in law enforcement, I would answer yes, and next explain why. As I see it, Herring's motion presents a particularly strong case for suppression. Electronic databases form the nervous system of the contemporary criminal justice operations. In recent years, their breadth and influence have dramatically expanded. Police today can access databases that include not only the updated National Crime Information Center, but also terrorist watch lists, federal government employee eligibility system, and various commercial databases. Moreover, states are actively expanding information sharing between jurisdictions. As a result, law enforcement has an increasing supply of information within its easy electronic reach. The risk of error stemming from these databases is not slim. Herring and Simichi warn that the law enforcement databases are insufficiently monitored and often out of date. Government reports describe, for example, flaws in NCIC databases, terrorist watch list databases, and databases associated with the federal government's employment eligibility verification system. Inaccuracies are expansive, interconnected collections of electronic information raise grave concerns for individual liberty. The offense to the dignity of the citizen who is arrested, handcuffed and searched on a public street simply because some bureaucrat has failed to maintain an accurate computer database is evocative of the use of general warrants that so outrage the authors of our Bill of Rights. The court assures that exclusion would certainly be justified if the police have been shown to be reckless in maintaining a warrant system, or to have knowingly made false entries or lay the groundwork for future arrests. This concession provides little comfort. First, by restricting suppression to bookkeeping errors that are deliberate or reckless, the majority leaves Herring and others like him with no remedy for violations of their constitutional rights. There can be no serious assertion that relief is available under Section 1983 of U.S.C. Title 42. The arresting officer would be sheltered by qualified immunity, and the police department itself is not liable for the negligent acts of its employees. Moreover, identifying the department employee who committed the error may be impossible. Second, I doubt that police forces already possess sufficient incentives to maintain up-to-date records. The government argues that police have no desire to send officers out on arrest unnecessarily because arrests consume resources and place officers in danger. The facts of this case do not fit that description of police motivation. Here, the officer wanted to arrest Herring and consulted the department's records to legitimate his predisposition. Third, even when deliberate or reckless conduct is afoot, the court's assurance will often be empty promise. How is an impecunious defendant to make the required showing? If the answer is that a defendant is entitled to discovery and, if necessary, an audit of police databases, then the court has imposed a considerable administrative burden on courts and law enforcement. Period. Justice Breyer, with whom Justice Souter joins, dissenting, distinguishing between police record-keeping errors and judicial ones, not only is consistent with our precedent in Evans, but also is far easier for courts to administer than Chief Justice case-by-case, multi-factored inquiry into the degree of police culpability. I therefore would apply the exclusionary rule when police personnel are responsible for record-keeping error that results in a First Amendment violation or Fourth Amendment violation. Next page, 92, is a new section, protected areas and interests. So I will stop the recording.